Welcome everyone to my YouTube channel. I hope that you are going to subscribe, hit the bell, and like my videos. This video is intended to give a lecture to the topic on legal documents, and this will be given in a Taglish language or Tagalog and English language for students to understand and comprehend well the context of legal documents. Well, legal documents are written instruments or written documents that conforms to the format of a department, an organization, or an institution, which varies from one agency or from one organization to another. And these are being prepared by an officer that is tasked to make a report or to make a document for purposes either of for record, for references, for future references, and for statistical data. This has the main objective of being compiled or being written or documented as an evidence. So what are the basic types of legal documents? We have three basic types. First, written instruments. Next, pleadings. And the third are reports. Written instruments talks about contracts, wills, trust. These are the most common type of written instruments, while pleadings has affidavits, memorandums, petitions, answers, complaint, and information. On the other hand, if we talk about reports, we focus on what we call police report writing or investigative or investigation reports. So let's take it step by step. Let's go first with written instruments. So the first type of a written instrument is what we call the contract. In Tagalog, kontrata. Ano nga ba ang isang kontrata? A contract is the meeting of the minds between two individuals who agreed into the performance of a particular thing or to give a particular thing for a particular or specific purpose. A contract may be verbal or written. Ang isang kontrata ay nangangahulugan na ito ay isang dokumento na nagsasaad sa agreement ng dalawang tao. So when letter A and letter B agreed to give each other something, then there is what we call a contract. Example, pag sinabi ni Pedro na, Maria, pupunta ako bukas sa bahay niyo, manliligaw ako. At sumagot si Maria, sabi niya, okay, pupuntahan mo ako ng alas 6 ng gabi. Since there is a positive response of Maria to the request of Pedro, then there is already an agreement. There is an agreement that is being consented to by both parties, Maria and Pedro, then there is what we call a verbal contract. If this verbal contract is reduced into writing, then this is turned into what we call a written contract. Now, contract as part of a written instrument on legal documents has to comply with three essential elements. Kailangan meron ang tatlo na ito. That is why it's called essential elements. The absence of one of essential elements will make the contract unenforceable. Meaning to say, pag wala ang isa sa mga elemento ng kontrata, hindi mo siya pwedeng i-enforce sa mga partido. You cannot force both parties to perform their own obligations if one of the elements of that agreement or contract is not present. So what are the elements of the contract? First, there must be consent of both parties. Consent or contract from the word contract, agreement, which means that both of the contracting parties must have given their consent. So nagkaintindihan kayong dalawa. So pag sinabi ni Pedro mamamanhikan o manliligaw siya mamayang gabi, at sabi ni Maria, okay, puntahan mo ako ng alas 6 ng gabi. Okay? If they reduce that into writing, kung sinulat nila yon at pumirma silang dalawa, that signature of them implies that they gave both the consent to that agreement. So, papaano kung yung kontrata ay isa lang ang pumirma? Okay? Pag isa lang ang pumirma, then there is a violation of one of the essential elements, which is consent. Okay? Meaning to say that the contract that is being signed by only one person is enforceable only to that signatory. Okay, I would like you to take a look on the example here on the right side of your screen. Okay? There is a signatory on the lower on the bottom part of the statement or the agreement. There is a signatory, Maria Juan and Pilar Pedro. Let's take for an example that they had written their signatures on top of their names. Once that you can see Maria Juan and Pilar Pedro's signature on this agreement, then meaning to say that they both agreed to the terms and conditions stated on the contract. So that is giving consent by both parties. Now, what if, in case Maria Juan did not sign? It's only Pilar Pedro who signed the contract. What is the impact of the contract? The contract now clause can only be enforceable to Pilar Pedro. But with respect to Maria Juan, the contract is void. The contract cannot be enforced against Maria Juan. Meaning to say that even if Maria Juan will not pay her promise of 30,000 pesos to Pilar, you cannot, or Pilar cannot enforce or force Maria Juan to perform her promise. Why? The absence of signature of Maria Juan in that particular contract is a presumption that Maria Juan did not agree to the terms and conditions on that particular contract. I hope you understand that. Now, what is the second element? The second element of a contract as a legal document is the object. If we talk about the object refers to the obligation of both parties. The obligation either to give or not to give, to do or not to do. Usually, the obligation to give or not to give talks about a monetary consideration. Like for example, in this contract that is given in your screen, the object to give is the amount of 30,000 pesos. While in fact, an object for a specific performance talks about an obligation to do or not to do a particular thing. In this example, Pilar Pedro has the obligation to do. She has the obligation to make or create a customized painting and to deliver it on a specific date, which is September 30, 2021. That is the object of this contract. The object to give 30,000 pesos and the object to create a customized painting. Okay, now the third element of a contract is what we call cost. The cost talks about the terms and conditions that is written in a particular contract. Usually, it refers to the penalties, sanctions, or conditions that are being agreed into by both parties in case a violation of the contract is being incurred. In this particular example, the cost of the contract is stated on the second paragraph, which says that said amount shall not be tendered upon the latter's failure to deliver on the stipulated date. So what is the impact if there is a failure to deliver on the stipulated date? The impact or the effect is that Maria 1 will not be forced to pay the amount of 30,000 pesos. So that is the cost. Taking into consideration that the three essential elements of a contract as a legal document is present on this example, then this example is a perfect and enforceable contract between Maria 1 and Pilar Pedro. You might be wondering why there were no signatories as two witnesses. I would like to remind you that a contract has only three elements: consent, object, and cause. And the presence of these essential elements makes the contract enforceable between the parties. It is not required, in order for a contract to be enforceable, that there must be witnesses to the execution of the contract. Hindi kailangan na merong magsasign na witnesses sa isang kontrata bago mo masabi na ang kontrata ay pwedeng i-enforce sa magkabilang partido. Valid pa rin ang contract kahit walang signatory ng mga witness for as long as the two parties who agreed for the performance of an act or to give something is the signatory of both parties. Tama na at magbabalid ang kontrata kung meron ang dalawang signatures or consent of both parties, kahit walang witness. The presence of witness was just being put by both parties if they agree into. Hindi siya essential element ng contract to be enforceable, but it is not also prohibited to put signatories as witnesses. Hindi naman nangangahulugan na bawal maglagay ng signatory ng mga witness or to call witnesses to the execution of the contract. Ang sinasabi lang dito, kahit wala yung signatory or signatures ng witness or kahit walang witnesses, for as long as both parties signed, both contracting parties signed the contract, then the contract is already valid and enforceable insofar as the parties are concerned. Enforceable sa kanilang dalawa yon. Kahit walang walang notarial seal yan or notary public na lawyer na nag-sign sa kontrata na yan, it is still enforceable insofar as both parties are concerned. Ang nangangailangan lang tayo sa isang kontrata class ng tinatawag nating signatory of the notary of witnesses and the notarization of a notary public or a lawyer in times of corporate contracts where they are being required and sa mga gustong makasigurado na maging strong ang kanilang grounds in case there is a violation on the terms and conditions. Yun lang yun. Yun kasi ang kinoconsider nila, they are already thinking about future court litigations. Kung sakasakali, magkakaroon sila ng violation on the contract and they need to go to court, then their grounds is more stronger because of the presence of the witness, the sign of the witnesses, and the presence of the notarial seal. Yun lang yun. But it doesn't mean that if there is no notarial seal and signatory of or signatures of witnesses, that the contract is invalid. Okay, so the next written instrument is what we call wills and testament. Actually, this is wills. Now, wills or a will and testament is a written instrument that is usually being executed by a person in articulo mortis. Articulo mortis is a Latin term which means in English at the moment or at the time of death. Okay. So, a testator or a person who is near, who feels that death is coming to him, that there is an imminent danger to his health, that he feels that any moment he would die, and he would execute or he would write a testament stating how should his properties be distributed in case he dies, then that instrument he executes is what we call a will and testament. Okay. It doesn't mean, however, class, that a healthy person cannot make a will and testament. Anybody who has properties to distribute may execute a will and testament. A will and testament is a written instrument which states or enumerates or give details to how properties shall be distributed to the heirs. Ito kailangan maintindihan nyo to kasi meron sa inyo yung mga mayaman dyan or hindi naman kailangang mayaman ka pero meron kang ari-arian na gusto mong maibigay ng tama doon sa mga tao na tumulong sa iyo or nakagawa ng mabuti sa iyo and you wanted to give back to them. Ito usually yung pwede nyong gawin na as a way of payback. Okay? You execute a will and testament. Okay. In the execution of a will and testament, there are also components or elements that we need to accomplish. First, that there must be a testator. Of course, wala tayong matatawag na will and testament kung wala yung tao na mag-execute ng will and testament. And we call him a testator. Pangalawa, that there must be properties subject of the will and testament. Hindi ka naman pwede na magsulat ng isang will and testament na wala ka namang i-distribute na ari-arian. At least, you have properties to distribute in order for you to make a will and testament. May bahay ka, pwede yan. Meron kang cellphone na gusto mong ipamana, pwede rin yan. Okay. But if you do not have any property to distribute, then there is nothing for you to write on that written instrument. Now, the third element should be successor or the presence of what we call the beneficiary. So what are the successor or the beneficiaries? Ito yung mga tao na gusto mong pamanahan. Kung ikaw ay ang may-ari ng mga properties, gusto mong pamanahan yung anak mo, pamanahan yung yaya mo, pwede rin lang yan. Now, merong mga ibang tao na mayayaman na kahit yung hindi nila relative, ay binibigyan nila ng mana. Like for example, a nanny, yung yaya nila, okay? Naging yaya niya, naging yaya ng testator, naging yaya pa ng kanyang mga anak, and he wanted to give a portion of his property to that particular person who is unrelated by blood or by affinity to him. Can he do that? Yes, by way of executing a will and testament. A successor in a will and testament, especially if it is an intestate succession, right, could be anybody else. It could be a stranger. It could be a relative, a close kin, a friend. Now, the fourth element is the presence again of a witness. Usually, a person who is at the point of death and executes his will needs the assistance of a witness. But this may be waived. Pwedeng hindi matupad yung ika-apat na elemento ng wills and testament, yung witness. Halimbawa, kapag ang isang tao ay malapit ng mamatay, sa Ilocano, ano ba yung term? Agsungsung-ab. Okay. He is battling with his breath, or he is gasping for his breath. So, gusto niyang gumawa ng will and testament. At that point of time, he needs a witness, the assistance of a witness, to write yung mga billing niya. Kung hindi niya kayang magsulat, pwede ang ibang tao to stand as a witness at maging writer ng testator. Yung testator ang magsasabi, isusulat ng witness. Okay? But there are also times that the presence of a witness may be waived in the execution of will and testament. Example, at this time of pandemic, when a person is tested positive to COVID, they are going to isolate that particular person in a quarter or in a room where nobody else would get in touch with him. Walang sinumang makakapasok, makakausap sa kanya, makakalapit sa taong positive ng COVID. Yan ang new normal ngayon with respect to health conditions ng mga tao as of this moment. Okay? So mag-isa ka sa loob ng quarantine area, you are depressed, you are emotionally tortured, and your body goes with your mind. So, nag-depreciate ang health, and then you felt that you are near your death. So, anong ginawa mo? You execute a will. Walang witness, ikaw lang mag-isa ang gumawa ng will mo. Pag namatay ka, will that will be honored in court? The answer is yes. Because insofar as the will and testament is written by the testator himself, stating all the properties he has and how these properties shall be distributed to his chosen beneficiaries or successor, then that will and testament is valid. Okay. There are two ways of succession. Paano ba ang isang tao ay magmamana? May dalawang paraan yan. Paraan na ginagawa ng korte, sa pamamagitan ng korte, that is what we call intestate succession, or the testate succession, sa pamamagitan ng wills and testament. Magmamana ka by way of the enforcement of the rules of law in intestate succession, here, intestate succession, or magmamana ka by way of the wills or the terms and conditions given in a will and testament, and that is testate succession. Where there is a will and testament executed, the court cannot go in between or meddle into the terms and manner of how these properties are being distributed. Paano yun? Ibig sabihin nun, kapag ang isang tao ay nag-execute ng will and testament, pag siya ay namatay, kung ano yung isinulat niya sa kanyang will and testament, ang siyang masusunod. Magreklamo man ang mga beneficiary na nakalagay doon. Halimbawa, magkakapatid. Tapos bigla may nakalagay doon pangalan ng yaya. Yung yaya ang binigyan ng pinakamalaking halaga. So, yung mga magkakapatid, nagreklamo sila sa korte dahil bakit nabigyan ng mana yung hindi nila kaano-ano. Okay? Will the court honor the complaint of these brothers or siblings? The answer is no. The court will just look into the will and testament. If to the authenticity of the will and testament, titignan lang nila kung totoong yung testamento na yon ay sulat kamay at nanggaling mismo sa kagustuhan or naaayon sa kagustuhan ng namatay or ng gumawa ng will and testament. At anong sasabihin lang ng korte, kung anong nakasaad sa will and testament, yun ang kagustuhan ng may-ari ng mga properties. So let us honor his will. Respetuhin natin ang kagustuhan ng may-ari ng mga properties nang nag-execute ng will and testament. Ayokong makialam, sabi ng korte. In intestate succession. What about in an intestate succession? Meaning to say, walang will and testament. Okay? Namatay si Juan, marami siyang iniwang property, pero meron siyang anak, pero wala siyang asawa, meron siyang yaya. Meron pa siyang parents. In that case, how will the properties of this person be distributed? And to whom should or shall the properties be given? Who will be his beneficiary or successor? Walang nakalagay ng wills and testament doon. Wala rin siyang asawa, pero meron siyang anak. Meron din siyang parents. Meron din siyang yaya. Will they get a part? Will all of them get a part of that? The answer to that, class, is it depends upon how the court will distribute the properties. It is now in intestate succession that the court will administer the distribution of the properties of the testator. Kasi wala silang guide na will and testament. So, susundin ngayon ng korte yung rules of law. Ano ba ang sinasabi sa batas about the distribution of properties? Example, pag namatay ka, automatic yon, kalahati ng ari-arian mo ay mapupunta sa anak. Okay, kung may 3 kang anak, halimbawa 100,000, namatay ka, meron kang 100,000 sa bangko, automatic yung 50,000 doon mapupunta sa mga anak mo. That is your direct descendants. Okay? Your son, daughter, your child. Kung 5 ang anak mo, 50,000 divided by 5. That would be their share. Okay? 1/4 or 1/2 of the half, that is 50,000 divided by 2, that's 25. So 25,000 will be given to the wife kung meron kang asawa. Okay? Meron kang anak sa labas, yung anak na legal, kalahati ang mamanahin. Yung anak naman sa labas, okay, ay katulad ng nanay, kalahati ng kalahati. Okay? 1/4. Now, that is what we call in intestate succession. Okay, let's take for an example, the one that is being stated on your screen. Okay, Hennessy has properties. She has 2 hectares of rice field, a black limousine, a garment factory, and a Say palace. Okay. Hennessy executed this will and testament. So Hennessy is what we call the testator. The 2 hectares rice field, the black limousine, the garment factory, and the Say palace are her properties. However, there is no mention as to who will get each property. There was no statement of a beneficiary and successor. Her nephew, John Smith Doe, is only being assigned by the testator as the sole administrator. Sole administrator is not the same as an sole heir. Ang administrador ng properties niya ay hindi pareho sa tinatawag nating tagapagmana. In fact, if you're going to read the context of this example, John Smith Doe was not even given a cent. Why? Because the testator, Hennessy, did not mention any successor or beneficiary. She just mentioned that John Smith shall be the one or will be the one to administer the distribution of the properties. But as to who will get an amount for a particular property, there was no mentioning of it. Okay? So this will, is this a testate succession? Will testate succession occur or intestate succession? Okay? This will take an example of what we call intestate succession. Why? There is a will, but the will is incomplete. It did not meet the third element of a will and testament, a valid will and testament. Hence, this will only become enforceable once intestate succession comes into place, where the court will be the one to determine who shall get 2 hectares rice field, the black limousine, the garment factory, and the Say palace. Okay. This is a different thing if the testator mentioned Jenny as the beneficiary of the 2 hectares rice field, Gary as the beneficiary of the black limousine, Dina or Diana to the garment factory, and Dino for the Say palace. If this is being mentioned in the will, then the will is valid and it takes what we call testate succession. And John Smith Doe, siya lang yung na-assign na maghahati o magbibigay sa mga naka-assign na property sa mga tao ito. Okay? In fact, kung titignan nyo si John Smith Doe, wala mana na ibigay sa kanya. Okay, so, this is a valid will and testament. Why? Because there is a testator. It's Hennessy. Properties, this one, and the beneficiaries, Jenny, Gary, Diana, and Timo. Okay. But there is no mention of witness. There is actually a witness class, and this is the lawyer. It says here attested by attorney, the name of the lawyer. Okay, so he stands as what we call as the witness. Though the presence of a witness maybe weigh in your will and testament. Okay, let's go with the third type of a written instrument, and this is what we call trust. Trust, this is not a thing, okay, that should be broken, sinasabi ng mga dalaga. But insofar as legal documents is concerned, trust portrays or means the meaning as you have read in the dictionary. In Tagalog, tiwala. Okay? Trust as tiwala. Now, written instrument. Trust as a written instrument complies or should comply with essential elements. First, that there must be a trustee. There must be a beneficiary. This is the beneficiary. This is the trustee. There must be fund. Where if it's not fund, if you talk about fund, it may be a thing. It may be monetary value, or it could be a thing that has monetary value, or the cash itself. Okay? And there must be delivery of the trust. To complete trust as a written instrument, there must be a delivery of this trust to the trustee. If you talk about trust, the trust is the thing itself that you have to deliver. Either it could be a fund or a cash, or something that has value. Next one, that the grantor or the maker of the trust must have title over it. Ang hirap yung magpapahiram ka ng isang bagay ng hindi sa'yo. Sabi nga nila, mga babae, huwag niyong angkinin ang hindi para sa inyo or ang hindi sa inyo. Diba? So, you must have a title over the trust. So, kayong mga dalaga, kung may example sa relationship, kung may asawa na yung tao, ibig sabihin, titulado na yung tao na yon, huwag nyo nang agawin. Okay? Kasi you don't have the title over that trust. It's the legal wife who have the title over his or his husband, or her husband, I should say. Okay? So, title over the trust. Must have title kung sasakyan yan or bahay yan, you must have title, legal title over that particular thing or the subject of the written instrument. Okay? That title is capable of being transferred or what we call transferable. Pwede ba yung titulo na yan i-transfer sa ibang tao? If yes, then it could fall into a written instrument called trust. If not, then it couldn't be. Okay? So just like for example here, so there is a graphic illustration or an image illustration. Okay? So there is a grantor. He assigned a trustee. Yes, there is the beneficiary. And here is the trust. Okay? The grantor gives the trust to the trustee for the benefit of the beneficiary. Okay? Like for example, si grantor merong titulo sa isang sasakyan. Okay? Yung sasakyan na yun ang tinatawag natin trust. Okay? Yung trust or yung sasakyan, i-deliver ng may-ari who has the legal title to it kay trustee. So, from grantor, ibinigay ang trust kay trustee. Ang sabi ni grantor, I'll give you my car, trustee, for you to use, but in one condition. You must have to fetch my daughter in the school after class. So sabi niya, sige, ibibigay ko sa'yo itong sasakyan ko. Pero, everyday, sunduin mo yung anak ko sa eskwelahan. Yun na yung pinaka-bayad ng paggamit mo sa sasakyan ko. Okay? So, there is the beneficiary. It's the nephew. Okay? So, the grantor gives his trust to the trustee for the benefit of the beneficiary. Okay? So, sana nakita niyo yung relationship of the image to the discussion of the written instrument called trust. Okay? I will not go deeply, or I will not discuss a thorough or comprehensive one in this particular topic, trust, because this is already a subject for law students. And there are some considerations that you need more to study before you could fully understand what is trust. So I am just giving you an overview of a written instrument. How does trust as a written instrument, okay, a legal document, works? So ganun lang yun ang portrayal. From the grantor gives a trust to the trustee for the benefit of a beneficiary. Now, let's go to pleadings. So the next basic type of legal document is what we call pleadings. Pleadings, as I have said a while ago, talks about complaint, information, affidavit, answer, reply, information. Okay, so a complaint is also a written instrument. That we call this a written document, which states the grounds upon which court's jurisdiction depends. Sa isang reklamo, or Tagalog ng reklamo is complaint. What is the English term for reklamo is complaint, ha? Sa yung iba, pag tinanong mo ano yung English term for reklamo, may nagjo-joke sabi lang reclaim because they don't know the term. So, complaint. Okay. Anong isang reklamo na nakasulat na reklamo or as a legal document? A complaint states the grounds. Ano ba yung mga basehan upang ang korte ay magkaroon ng jurisdiction sa kaso? Okay? Sakop ba ng otoridad ng korte yung reklamo mo o baka naman sakop lang ng barangay? Halimbawa, alarms and scandals. Nalasing si Juan, nagwala si Juan, naistorbo si Ana, nagreklamo si Ana. Okay? So, tinignan ngayon, pumunta si Ana sa municipal trial court. Nagreklamo siya, nareklamo niya si Pedro for being drunk at nagwawala ng 10 oras ng gabi, nakakaistorbo. Okay. Now, the court will look into the ground of Ana. Ano ba yung basis ni Ana to file the complaint? Nakita niya alarms and scandals. First degree alarms and scandals. Because it's the first offense and it only caused disturbance to Ana, hindi sa whole community. O, sabihin na natin si Ana lang yung nadistorbo kasi siya lang yung reklamo. Okay? So, the court will not acquire jurisdiction. Ang gagawin ng korte, sasabihin kay Ana, pumunta ka sa barangay nyo, doon mo ireklamo si Pedro. Why? Because based on the grounds that Ana stated on his complaint, on her complaint, the court cannot acquire jurisdiction. The court has no jurisdiction over the case. Okay? Okay. What else is in a complaint? Ano pa yung meron sa isang reklamo as a legal document? There must be a claim showing entitlement to relief. Pag nagreklamo ka, kasabay nun, meron kang sinasabi na dapat para sa'yo. Okay? Oh, may sinasabi ka sa korte na gagawin nila para sa'yo. Entitlement to relief. You have a claim. O, halimbawa, balik tayo kay Ana. So, nagreklamo si Ana. Sabihin na natin, in-acquire ng court yung jurisdiction. Okay. Palitan natin yung facts and case. Si Ana, nadistorbo sa tulog, lumabas dahil narinig niya yung pagwawala ng kakailan si Pedro. Tapos nung sinabihan niya si Pedro, sinampal siya ni Pedro. So, kinabukasan, nag-file ng case si Ana sa Municipal Trial Court. Not alarms and scandals, but slight physical injuries because of the spanking. Okay? Will the court acquire jurisdiction sa grounds ni Ana? Yes. The court will acquire jurisdiction on the case of slight physical injuries. Okay. What is the claim of Ana? Sabi ni Ana, kailangan na bayaran ako ni Pedro. Kailangan mapatigil niya si Pedro sa paglalasing o pagwawala kapag nalalasing. So that's the claim of Ana. Sabi niya, hindi ko pinovoke si Pedro. Pumunta lang ako doon, sinabihin ko si Pedro, and then sinampal niya ako. So there's a claim. There's a claim of unprovocation. Okay? There's a claim that there is no existing provocation on the part of Ana. So there's a claim. So next is demand. Demand for judgment or relief. Ano yung state mo sa complaint mo? Anong kasama doon? Dapat kung ano ang hinihingi mo sa korte na gagawin niya. Sinasabi mo doon, gusto ko sana na maikulong si Pedro at bayaran niya ako. Lalong-lalo na ang ginastos ko sa pagpapagamot sa sinampal ng mukha ko. Okay, that's the demand for judgment or relief. You are demanding that you are asking the court to declare Pedro guilty of slight physical injuries, and that you're asking the court for a relief. What relief is that? That Pedro will be incarcerated and he will pay for damages. Okay? So that is what a complaint should contain. The grounds for your complaint. Ano yung mga, what are the grounds? Ano yung mga basehan mo para magreklamo? Ano yung claim mo na totoo? Halimbawa, si A umutang kay B, hindi niya nabayaran. Nagreklamo si B for collection of sum of money. Nag-acquire ng jurisdiction ng court. Ano ang claim ni B? Sabi niya, siningil ko si Ana, or siningil ko si A, hindi nagbayad. Pabalik-balik ako doon sa kanila and she was ignoring me. That was the claim of B. And what is her demand? I am asking the court, requesting the court to declare A guilty of estafa, maybe, okay, or unpaid debt. And I am demanding, I'm asking the court for a relief that payment shall be done to me, okay, by the accused. Ayun ang complaint. Meron kang demand, meron kang hinihingi sa korte na gawin para sa iyo. Meron kang claim. Meron kong sinasabing ito ang totoo, ito ang ginawa ng accused, then you have grounds. Ito ang mga basihan ko kung bakit ako nagrereklamo. That is complaint. Okay. Now, what about our information? When you go to the police station and files for a police blotter, the police blotter will be forwarded to the appropriate officer, and if you want to file a complaint, the complaint will be prepared by the investigator, and after the filing of the complaint, the investigator will forward that complaint to the prosecutor. Ipapasa niya ngayon yung investigation report niya, yung reklamo mo doon sa prosecutor. The written accusation now prepared by the prosecutor. Anong gagawin ng prosecutor doon sa pinal mo na complaint sa kanya? Ipinasa mo na complaint sa kanya. The prosecutor will determine if there is a probable cause to file the complaint. Titignan niya kung totoo nga yung grounds na nilagay mo doon sa complaint ay talagang pwedeng maging basihan para ma-declare na guilty yung akusado. At titignan niya kung meron kang basihan, matibay na basihan para magreklamo. Okay? Once that there is a probable cause, the prosecutor now will prepare a written accusation based on the complaint, based on the investigation report forwarded to him by the police officer. And that written accusation is what we call information. So what is the difference between a complaint and an information? The same sila ng laman, okay, that they contain the grounds, the claim, and the demand of the complaining party. Only that the complaint comes directly from the statements of the complainant, while the information is based on the facts forwarded to him by the investigator. The complaint is being signed by the complainant. The information is signed by a prosecutor. So it is the prosecutor that will sign the information. The information is then filed before the court. Okay. Now, after the filing of the complaint with information by the prosecutor, depositions or statements coming from witnesses, coming from the arresting officer, coming from the investigator will be taken. And these statements as to the circumstances of the incident or surrounding the crime or the case are what we call affidavits. This affidavit is a written document containing the statements of an individual as to the facts of the case, and that the affiant, the one executing the affidavit, is what we call the affiant. The affiant shall took this oath by placing his signature on his affidavit with what we call as executed in his free will, that there was no force and intimidation exerted upon the person of the affiant to execute his affidavit for or against the accused or the complainant. And this affidavit shall be submitted to the person in authority. Okay? So affidavit contains the statements of facts surrounding or circumstances of a case with the oath of the affiant that such is being executed by him on his free will and or voluntarily done before a person in authority. That's why if you were able to take a look into a sample affidavit, you could see there a portion which is this: subscribed and sworn to before me this blank blank blank, and signed the notary public. Notary public is the person in authority. Okay? So the facts of the case, well, it includes the 5 W's and 1 husband to complete the circumstances of the case. The oath is, and the free will of the affiant is being presumed upon the attachment of his signatory. Okay, another pleading is what we call an answer. An answer contains the statements of defenses of a respondent, defenses of the accused. That is an answer. You file a complaint against A. A will make his answer to your complaint. Okay? So, what will he put in his answer? His grounds or his defenses. Sasabihin niya, I specifically deny paragraph 1 of the complaint. The truth of the matter being, lalagay naman niya kung ano yung side niya. Ano yung grounds niya kung bakit niya tinutuligsa yung paragraph 1 ng iyong reklamo. Halimbawa, sa complaint mo, complaint of sexual harassment, nilagay mo doon that the accused touched my breast. Okay. In his answer, sasabihin naman niya, I deny paragraph 1 in the complaint. The truth of the matter being that I just accidentally touched the breast because I was getting something near that person. Okay, so that is the claim. That's the defense of the respondent. It could be a defense or alibi, but what I want you to understand is the answer. Okay? So, ang tawag doon, pag nag-file yung victim ng complaint, ang tawag sa sagot ng akusado ay answer. Katapos sumagot ng answer, okay, tapos natalo sa kaso, a petition may be filed. A petition is actually a written request to the court to perform something, to allow something. Halimbawa, we have what we call a petition for mandamus, petition for certiorari. Petition for certiorari under Rule 45 or 65 of the remedial law, okay, is a request before the court to review the decision of the lower court. So you are requesting the court, the higher court, to review the decision rendered by the lower court. Halimbawa, nag-file siya ng complaint ng sexual harassment, file siya ng answer, lumabas yung judgment, guilty. Ang ginawa ngayon ng akusado, he files for a petition for review or petition for certiorari. That is a written request to the appellate court, that is the Court of Appeals, to review the decision of the lower court. It could be the RTC or the MTC. Okay? I-review niya ngayon yan. Once the complainant is going to answer also the petition, ang tawag na natin doon kasi is reply. So, complaint from the victim, answer for the defendant or the accused. An answer to the answer is a petition, okay? Petition for review. And an answer to a petition is what we call a reply. Okay? Reply. Okay. So that is what we call a pleading. Now, we are now going to discuss the nexus or the core topic or the core lesson of this course, and that is what we call police reports. Police report writing takes a notch on every organization of the law enforcement agency. Police report writing, according to survey, has been one of the problems of the organization. Why? Because there are a lot of police officers who fails to conform with the proper way of police report writing. Okay. So there are types of police reports. We have incident report, that's an initial report, the spot report. Incident report is actually sometimes called the spot report, but more particularly it's the police blotter. Okay. Next to the initial report is the progress report. The post-operation report. A progress report is a report that pertains as a follow-up report on the incident. So, gumawa ka ng incident report mo, initial report mo. After a week, gagawa ka ng progress report. Ilalagay mo doon sa progress report mo kung ano na yung progress, ano na ang nangyari doon sa case na yun. Okay? What are the steps that you have undertaken? What has been done? Okay? Is there a resolution to the case, or the case has worsened, or whatever situation has been done for the case? Progress report. Post-operation report usually is being prepared after a successful operation, police operation. Yung pagkatas, halimbawa, may raid kayo na isang bahay, drug den, supposed drug den. So after, if that's a success operation, you have to, the person in charge that is tasked to do the report has to prepare a post-operation report. And then the last type of police report is what we call the final report. Okay, this is a report stating the resolution of the case. How did the case or the incident being settled? Was it finally settled, or is it still an ongoing case? Okay. But aside from this investigative or investigation reports, we have the daily journal and the police blotter. There is a traditional way of writing a police blotter, okay, that is by using what we call the logbook. Ito yung ginagamit nila pag pumasok ko sa isang police station, may ire-report kayo, okay, yan yung logbook, yung blue ang color, na ino-open nila at doon nilalagay yung ire-report mo. Okay? Daily journal usually is already included in the police blotter, but usually a daily journal contains only the daily activities, what happens on the day-to-day duty of a particular police officer. Halimbawa, wala namang nagreklamo na residente sa nasasakupan nyo. So, you still need to put something in your daily journal. Ano ang nangyari doon? You might state that the post duty on that, you have rendered duty on your post from 8 to 5 and properly turn over the things on that particular office of yours by the end of your duty to police corporal, the name of the next desk officer or the next person that will be in charge. Okay, so that would be a daily journal. Sometimes daily journal contains only non-critical informations. Okay? This only pertains to the daily activities, which does not involve cases, resolution of cases. Unlike in police blotter, that in a police blotter, what is being stated there is are the things that are informations that are being uh, reported or forwarded to them by an informant or by a particular person who walks in the station or in that particular unit. Okay. Now, there is an example that is being given to you here. This is actually the same as true with your activity that was given in classroom. Okay, so it is a simple statement of an incident that happened in August 4, 2021, wherein a man, okay, went to uh, a particular a particular payment center and execute or requested that an amount shall be transferred to his account, wherein the owner also agreed to transfer the amount only to find out that the paper bill paid to her was or were, I should say, uh, fake. So that was the incident that was being written on that paper or document. Okay. Will you consider this as a police report, or will you consider this as incident report, a spot report, a progress report, post-operation report, or a final report? Or could it be properly be inserted in a daily journal, or should it be written in a police blotter? Actually, the example given to you, class, was not a police report. It's not even a report. Uh, it's not actually a formal legal document, but it is a written report in its general sense. It is a letter to a person or to the person concerned, informing him of uh, a violation done or a crime that is being done. Well, paying counterfeit money is a violation to the law. Okay? If that letter is being forwarded or being relayed to a police officer and is entered into the log book, then that could be considered as a police blotter. Okay? So there are different types or different purposes why a person would go into a police blotter. A police blotter is not the same as a complaint. It doesn't mean that if you go to the police station and state some facts of a crime that is being done, okay, or complaints for something that have happened, it doesn't mean that you are already or that the person you mentioned in that information will be arrested. If you do not intend to file for a complaint, then it will remain as a police blotter. There are purposes like, for example, a police blotter is being executed for purposes of record, for future references, for an immediate action. Like, for example, you execute a police blotter regarding an ongoing shooting incident, then the purpose for the police blotter is for police assistance. Right? And if the purpose of your blotter is for police assistance, well, of course, it must be construed or understood. It is understood that the police should deploy or dispatch his men to offer the assistance that you are requesting. So a police blotter is not the same as a complaint. It doesn't mean that if you executed a police blotter, that you have executed a complaint against the person involved in that incident. And so you must have to understand that. Okay, so that is the end of the discussion. Uh, I will not go further into the details of police reports because we will go into it step by step, starting from the very first step of making an incident report or a police blotter. Okay, that is why I have required you in this course that the output in the finals for this course is for you to submit what we call a case file. I grouped you into 3 to 4 groups in a class and assigned cases for each group. So makikita nyo doon sa groupings ninyo, group 1, may nakalagay doon murder. So that will be the case that you are going to prepare. What are you going to do? You assign a team leader for each group. Okay? After assigning a team leader for each group, you make the facts of your case. Like for example, your case is murder. It is now for you or your assignment or your task to draft the facts of your case. Kayo ang gagawa ng facts of your case. Ano ang nangyari sa kaso nyo? Anong kaso yan? Kung murder yan, anong nangyaring murder? Paano nangyari ang murder? Okay. You answer particularly, of course, the 5 wives and 1 husband in making the facts of your case. Okay? That is the first activity that you have to do. Make the facts of your assigned case. Okay? Each member shall draft an investigation report of the case. So each member, meaning to say, has to make her own facts of the case. And then after that, you deliberate with the members of your group. Mag-usap-usap kayo, ayusin nyo, basing from the given facts of the case. And then make one final facts of the case. Mag-settle kayo ng isa lang na facts of the case. And yung team leader ninyo, iko-collecta niya lahat yung individual facts of the case regarding murder, kung murder yung naka-assign sa inyo. And in front, yung pinaka-ibabaw ng work ninyo na naisasubmit sa akin is yung unified facts of the case. So, ulitin ko, lahat kayo gagawa ng facts of the case depending on the case assigned to you. Because it is where I will base your individual score. Pagkatapos nyo mag-draft ng ganon, ibigay nyo or mag-usap-usap kayong lahat na membro ng grupo at pagsamasamahin nyo kung anong maganda doon sa work ng bawat isa, and then you settle to one facts of the case. Okay, gagawa kayo ngayon ng pinaka facts of the case ninyo as a group. At iyon ang ilagay ninyo sa ibabaw nung individual draft of the facts. And give to the group marcher or to the group leader, because the group leader will be the one to submit the case file. Okay. Yun yung first part of the case file. Gawa kayo ng facts of your assigned cases. Caveat, or what we call a warning. Unparticipative members shall be dropped from the group and shall submit an individual case file at the end of the course. Okay? So, sabihin lang ninyo kung sino yung member na hindi nag-participate, walang i-contribute, at aalisin natin siya sa grupo ninyo, and he will be required to make his own individual case file. So, that will be your first assignment. After you make the facts of your case, you will proceed with the next step, which is police blotter. Thank you very much for listening again to my YouTube channel, and I hope that you're looking forward to the next videos. Bye bye.